Title 5, Bylaws, Section 46, Adoption of Bylaws. Every corporation formed under this code must, within 1 month after receipt of official notice of the issuance of its certificate of incorporation by the Securities and Exchange Commission, adopt a code of bylaws for its government not inconsistent with this code. For the adoption of bylaws by the corporation in the affirmative vote of the stockholders representing at least a majority of the outstanding capital stock or of at least a majority of the members in case of non-stock corporations shall be necessary. The bylaws shall be signed by the stockholders or members voting for them and shall be kept in the principal office of the corporation, subject to the inspection of the stockholders or members during office hours. A copy thereof, duly certified to by a majority of the directors or trustees, countersigned by the Secretary of the Corporation, shall be filed with the Securities and Exchange Commission, which shall be attached to the original articles of incorporation. Notwithstanding the provisions of the preceding paragraph, bylaws may be adopted and filed prior to incorporation. In such case, such bylaws shall be approved and signed by all the incorporators and submitted to the Securities and Exchange Commission together with the articles of incorporation. In all cases, bylaws shall be effective only upon the issuance by the Securities and Exchange Commission of a certification that the bylaws are not inconsistent with this code. The Securities and Exchange Commission shall not accept for filing the bylaws or any amendment thereto of any bank, banking institution, building and loan association, trust company, insurance company, public utility, educational institution, or other special corporations governed by special laws, unless accompanied by a certificate of the appropriate government agency to the effect that such bylaws or amendments are in accordance with law. Section 47, Contents of Bylaws. Subject to the provisions of the Constitution, this code, other special laws, and the articles of incorporation, a private corporation may provide in its bylaws for 1. The time, place, and manner of calling and conducting regular or special meetings of the directors or trustees. 2. The time and manner of calling and conducting regular or special meetings of the stockholders or members. 3. The required quorum in meetings of stockholders or members and the manner of voting therein. 4. The form for proxies of stockholders and members and the manner of voting them. 5. The qualifications, duties, and compensation of directors or trustees, officers, and employees. 6. The time for holding the annual election of directors or trustees and the mode or manner of giving notice thereof. 7. The manner of election or appointment and the term of office of all officers other than directors or trustees. 8. The penalties for violation of the bylaws. 9. In the case of stock corporations, the manner of issuing stock certificates. And 10. Such other matters as may be necessary for the proper or convenient transaction of its corporate business and affairs. Section 48, Amendment to Bylaws. The Board of Directors or Trustees, by a majority vote thereof, and the owners of at least a majority of the outstanding capital stock, or at least a majority of the members of a non-stock corporation, at a regular or special meeting duly called for the purpose, may amend or repeal any bylaws or adopt new bylaws. The owners of 2/3 of the outstanding capital stock, or 2/3 of the members in a non-stock corporation, may delegate to the Board of Directors or Trustees the power to amend or repeal any bylaws or adopt new bylaws, provided that any power delegated to the Board of Directors or Trustees to amend or repeal any bylaws or adopt new bylaws shall be considered as revoked whenever stockholders owning or representing a majority of the outstanding capital stock or a majority of the members in non-stock corporations shall so vote at a regular or special meeting. Whenever any amendment or new bylaws are adopted, such amendment or new bylaws shall be attached to the original bylaws in the office of the corporation, and a copy thereof, duly certified under oath by the corporate secretary and a majority of the directors or trustees, shall be filed with the Securities and Exchange Commission, the same to be attached to the original articles of incorporation and original bylaws. The amended or new bylaws shall only be effective upon the issuance by the SEC of a certification that the same are not inconsistent with this code.